right, well, hello everyone. Thank you for joining our webinar today. We're going to be talking about data privacy and security and how laws around that relate to your business, which is very important. So we're happy that you've joined us today to go over that. I'm going to go over just a few things to get us started, and we'll also allow some time for a few others to be joining us today. But first of all, we are recording the session and we'll send out the video afterwards along with the slides so that you can refer back to the material. So don't worry if you're scrambling to take notes, you'll have access to all of that. And we also want this to be as interactive as possible. We love to hear your questions. So feel free to put those into the chat during the presentation so you don't forget them. And then we'll have time to get to those either during some breaks during the presentation or afterwards. And yeah, any questions can go into there. So just to get us started with a few brief introductions, I'm Hannah Curtis. I'm with the North Metro Small Business Development Center. For any of you who aren't familiar with the SBDC, we offer free one-on-one consulting with our business experts, as well as some educational opportunities like this webinar today. So to find out more about how you can get involved with the SBDC, you can visit our website, which I'll put into the chat here in a minute, but it is northmetrosbdc.com. Or you can always reach out to me after the session today. I'll put my email in the chat as well. So today we're joined by Samantha Peaslee. She's an attorney with Polaris Law Group and a longtime SBDC legal consultant. So we're so happy to have her on our team and excited to hear what she has for us today about dealing with data. So with that, Sam, I will turn it over to you.
Awesome. Thank you so much, Hannah. It's good to see everybody here today. Thank you for joining us. I am going to pull a PowerPoint up here to kind of help guide us as we go along. Hannah will have the slides after this in case anybody needs extra copies. And we also have our PowerPoint friendly subtitles on as we go along. I do not control the subtitles. I have not told PowerPoint what is going in there, so I do apologize if any words that should not pop up do pop up. It's never happened, but it is always a little bit of a concern of mine. So, but hopefully that's helpful for people as well. Like Hannah said, thank you for joining us today. We are dealing with data as it relates to small businesses. That means data collection, data privacy, all of that fun stuff that we're going through. I'm Samantha Peaslee. I am a partner with Polaris Law Group. We are in North Glen, Colorado, but we operate all across the Front Range. We serve as external general counsel for small to medium-sized businesses. So that's who I focus on. And then within our office, I'm the specialist in intellectual property, data privacy, which is why I'm here today, as well as international business transactions. And while I'll be referring a little bit to some of the international concerns with data privacy today, that's not going to be the main focus of our talk. You know, if anybody is working with the EU, with Canada, with Mexico, with any of those countries with data, as Hannah said, we do consults with the SBDC. You can always sign up through the SBDC for a free and confidential consult with me there. I can't provide legal advice, but we can absolutely talk through any of those. And so I'm going to say with any questions that people have today, please ask them. But if something goes a little too deep drilling into your personal business, and I don't think that it's going to have good application for the rest of the group here, I'm going to say sign up for a consult with the SBDC. Not trying to push anybody off as far as that goes, but I'm going to try and keep our questions that we answer here today ones that we generally think are going to help the group as a whole. But please pop your questions in the chat as we go along. What we'll do is we get to section breaks. I'll take questions that relate to the section that we were just in so that we don't go too far away from something before we loop back to it with questions. So feel free to ask them as we come along. Does not interrupt, does not bother me in the least. I'm going to ignore them till we get to the end of a section and then we'll answer all of them. But also if anybody's having trouble hearing or things like that, please pop that in and Hannah will let me know. We'll go into that. So data. I'm actually starting this with what law applies. Now, I used to start this presentation with what is data, but what I've learned is a couple of things. One, most people know what data is. They know what their stuff is. But two, we actually kind of have to start with what law applies, because what matters as far as the data we're collecting depends on the law that we're looking at. So as we've gotten into our internet fully connected world, we've realized that we don't all have the same definition as to what we care about as far as our personal data goes. But in general, when I am talking about this and what applies to your business, when I'm saying data generally, I mean any tiny iota of information that you are collecting from your clients, your vendors, your employees that you use in your business. So my definition for our general terms is super, super broad, just anything that you're collecting from anybody. But then when we're trying to figure out what you actually need to protect, what you actually need to do, what might apply as far as restrictions, regulations on that data, we have to look next at what law applies to determine what our definition of data is. So I have 4 items here that we use to help us determine what law applies. And for some of us, multiple laws will apply to the data that we collect. So first, we care about where the people from whom you collect the information live or reside. So if you have customers in Colorado, Colorado law applies. If you have customers in California, California law applies. If you have customers in Iran, Iranian data law applies. So we first look at a very, very base level, where the people from whom you're collecting the information reside. Second, we look at where your business actually conducts its business. Now, for some people, those two are the exact same thing. For some, we're like, well, I'm in Colorado and I sell some things in Wyoming and maybe over a little bit to Nebraska. And that's where I conduct my business. But then if you have somebody buy your product over in Maine, then category number 1 also applies to you. So you might have 1 and 2 be the same. You might have them be different. Third thing that matters is what types of data you're collecting. Different laws are going to apply if you're just collecting people's favorite color, then with no other information than if you're collecting their fingerprints to sign into your app. Different laws are going to apply if you're collecting medical information than if you're collecting their preferences on shoe size. So the type of data that you collect will impact what kind of law applies. And fourth, what industry you're in. So some industries, regardless of what they actually collect personally, may have some broad overarching regulations there. There's another category here that I didn't actually put in here, but that does also matter. And that is if you are collecting data from children. And we will talk a little bit about the Children Online Privacy Protection Act, but if you're collecting data from anyone 13 and under, that will also have some special applications here. So I didn't put that here because it's kind of it does or it doesn't. But that is another factor to think about. So we look at what law applies. Now today in our presentation, we're going to be focused mostly on the Colorado laws, because I'm assuming if you're here at the North Metro SBDC that you care about the Colorado laws. So the first and the one that is currently in place are the Colorado Consumer Data Security laws. So these apply to anyone, whether you're a person or a business, if you have or keep or own any PII, which we're going to define in a second, of any Colorado resident. So for most of us who do business in Colorado, this applies. If you have any, let's not worry about definition of PII yet. Let's see, by a show of hands, if you keep any information of any Colorado residents in the course of your business, raise your hand. Any at all. If you have any employees and you have their names and their email addresses, if you ship things to clients and you have their physical addresses, that's you. So these are the ones that kind of at base control, and they're currently in effect today. Now, we're also going to talk a little bit about the Colorado Privacy Act, which is not yet effective, but which we already know about. So the Colorado Privacy Act covers a narrower group. It covers any business that conducts business in Colorado or sells products or services that are targeted to residents of Colorado, and either process the data of 100,000 consumers in a year or derive revenue from selling personal data or processing data of 25,000 consumers. So most of the time, our SBDC clients do not fall into this category, but some of you might. And we're still going to talk about how that interplays with some of these laws that we have when we're dealing with things, especially what does sale of personal data mean, or what does control or process of personal data mean? So our data security is going to be our main law that we're worried about, but we will talk a little bit about the Colorado Privacy Act as it's coming up. Then other ones that often come up for our Colorado residents are the California ones. Why does the California one apply? Because California is the strictest privacy rights law in the United States. And if you are selling to residents of California, kind of in the same way that we were under the Colorado Data Privacy Act, it may apply to you. So the California Privacy Rights Act is actually the new version coming in play January 1st, 2023, but there is another version of it previously that tracks a lot with the Colorado ones, is a little bit stricter. So that will apply to a lot of companies that do online stores or online sales, not so much online services necessarily, unless you're looking at California. The EU GDPR is one that a lot of people know about. It's kind of considered one of the gold standards as far as data protection for consumers, but that does mean it's a little trickier for businesses. That's if you collect any of the data of an EU resident. Those are some of the well-known ones. Each country has its own, a lot of countries have their own, not every country has their own. I also included HIPAA as a good example. We know that one, that's the Health Portability Act. So if you're collecting health information of clients, that will apply to you. The CAN-SPAM Act will apply to things like newsletters or online communications. Children's Online Privacy Protection Act we talked about, and then other industry-specific laws and regional laws. So we're going to focus largely on those Colorado ones, but these are some of the other ones that might affect some of you here on the presentation. So before we jump into our next section, let's see if we have any questions.
Yeah, looks like there are a few. Kevin asked a good question about if bars and restaurants can be required to allow them to scan driver's license for entry or some kind of identification for entry.
Sure. So we're going to be talking about what the requirements for do's and don'ts are on here as far as that goes. But so we'll talk about that as we get deeper down into what the laws and acts allow you to do, and don't allow you to do. So we'll come back to that one. Good question though.
Okay, great. Thanks. Here's a really interesting one as well. Does the Data Privacy Act, does that see nonprofits and for-profits in the same light?
Great question. Yes. So there are really three categories in the Data Privacy Act: individuals, governmental entities, and then non-governmental businesses. So if you're a nonprofit, for all of our purposes today, you're lumped right in there with businesses. If you are a governmental entity, you are going to have your separate set of rules, and we're not going to get into those too much today. But if you feel like you might fall more into that category, that's a great one to set up a consult with me, and we can absolutely talk about those differences there.
Great, thank you. And then Stacy has a question that I was wondering as well. If you're doing business in, several different states, as was you mentioned in your example, is there a place you can go to find out what all of those regulations are, or do you just need to go state by state? What would you recommend?
That'd be really great if there was a place that you could go to find out what all those regulations are. But honestly, most of this is so new. That if you're not GDPR or California consumer protection, most people don't bother unless you're industry regulated. Obviously, industry regulations follow your industry regulations. Colorado is one of only 4 states that actually has a deliberate privacy act at this point. So Virginia is another one. Most states have data protection rules and laws buried in other consumer protection statutes. So they don't necessarily have a dedicated data privacy statute. So if you're working in 2 or 3 other states, that's one where I highly recommend either working with an attorney to figure out what your regulations are, or working with that particular state's Secretary of State office or their SBDC to figure out what those regulations are. Otherwise, if you're doing like a lot across the US, you can't go wrong with California. Unfortunately, it's the strictest, but it's also, if you have people across every state, that at least has to apply to your California residents. This is not attorneys' favorite things right now, that everybody's kind of doing their own thing, because it means we have to keep track of a lot of different ones. But right now, what I've been recommending to people is, if you work in multiple states, let's just assume that California applies to you and you'll be covered as far as the rest of them go.
Great, thank you. Makes sense. And looks like that's the end of our questions for right now.
Awesome. So we're going to keep going. And I have an idea of where to answer the driver's license question, but if I get all the way to best practices and I've forgotten, please remind me. Let's jump into what we mean by some of these quick definitions here. Personally identifiable information. Personally identifiable information is usually the data that we actually care about here. So remember, I said, for my purposes, data is anything that you collect it. That's just what you get in order to do your business. But what most of these protections actually protect is what we consider personally identifiable information. Like I said, PII is defined differently in each of these different laws, but there are some things that are kind of always considered PII, and some things that if you assume that they're PII, you should be okay. Generally speaking, you want to think about it as something where if someone got this piece of information, they could steal your identity, they could take money from your bank account, they could conduct fraud, they could get into your email. So it's that stuff that you don't want someone else to have. It's pretty simple. That's PII. So some things that are pretty universally PII: social security numbers. That one's kind of a gimme. Personal identification numbers. Some statutes have where the personal identification number has to be paired with something like a bank account in order for that to be in effect. Passwords, passcodes, official state ID numbers, government passport numbers, biometrics. That's a big one, and there are some laws specifically governing biometric data. Employer, student, or military ID numbers. That's one of the ones that in some places that is considered PII, and some it's not by itself. Any financial transaction devices, that would be if any of you ever get a scrambler or anything like that, or a specific device that is the only one that can access a bank account. That's what we mean by financial transaction devices. And financial account numbers, credit card numbers, bank account numbers, retirement account numbers. PII, the things that you don't want somebody else to have. There's also a category just called personal information that is protected in some of these things, and it might not be as strictly protected. This is more what I've seen small businesses collect, quite frankly, because these are combinations of things that we might need in order to run our business. So for example, in Colorado, if a resident's first name or initial plus a last name in combination with another piece of PII. So it's not enough just to have their first and last name. We've also seen some protection in the California laws given to first name, last name, address. Address by itself, not. First and last name by itself, not. You combine them and all of a sudden you can do a lot more damage. Usernames or email address in combination with a password or security questions and answers. So this is where sometimes doing the surveys about favorite ice cream flavors might not be helpful to you as a business, unless that is what your business is oriented around. Why? Because if that's a security question to answer, and you also happen to have whatever login you have for their site, you may now have created a category of information that you need to protect. Account number, credit card, debit number with any required PIN number, access code, password, makes sense, right? If you have the piece of financial information and the thing to get into the piece of financial information, that suddenly becomes more powerful. What is not considered personal information is any information lawfully made available to the general public from government records or widely distributed media. So we can see how kind of from the stepping back as business owners from the personal side, how we can get ourselves in trouble on some of this, right? If we're starting to put all of our pets' names and the street where we grew up and things like that on social media, we may have lost some protection that we otherwise might have had. On the other hand, you as business owners, your business's address plus your first and last name may not be personal information. Why? We have to put that in the Secretary of State site every year. If you have things that you're filing in court to enforce a lawsuit, you want to be careful about what is covered under a protective order and what isn't, because if you make it public, then it might have lost that protection as personal information. So we're worried both about those things that we're like well, duh, we want to protect that, as well as things that by themselves may not be enough, but put together with something else would allow you to get more access to someone's life. So that's kind of some of those definitions that we're working with. So with that, we're going to jump into what some of the consumers' rights to their PII and personal information is. So here we're talking about things that you as a business need to know that you need to be careful of when working with consumers. These are things that they get under various ones of these acts. So first of all, and this is kind of one that's been a little bit in play, but is really starting to happen, is what's called an opt-out right. So an opt-out right is saying that consumers are allowed to say, you can't use my personal data in X way. So for example, when we get to our obligations as companies, you're going to see that we have an obligation to clearly tell consumers what we use their data for. So let's say you're an online store, and let's say you ship people plants. And so what do you need in order to get their plants? Well, you need their address. You need to take in their payment information, and we'll talk a little bit about third-party programs and how that can be helpful on that one. So you'll get their payment information. You need to get a phone number in case something goes wrong or there's a delay. You need to get an email in order to send them that confirmation. Okay, so you're collecting that piece of information. Can you then, show of hands, who thinks that we can do this? Can you then use that information for sending out your newsletter? Who thinks yes? What about for sending out coupons? What about for telling them that there's been a delay and that they won't get their plants on time? Okay, so you can do all of these things if you have in your privacy policy that this is how you will use it. But if they're not directly related to the service or good that they're receiving from you, they have to be able to opt out. And it has to be clear and conspicuous how they opt out. It has to be in the notice. It has to be in a readily accessible location. So like a contact us form or a clear email address where they can do it. You can't hide it in itty bitty little fonts. And so if you say, here's the data that we collect and we use it to fulfill your order, to update you on any shipping issues, to communicate with you regarding your product, as well as we will use it to send you a newsletter, to send you updating offers and coupons. You then have to say anything except fulfilling your order, you have the right to opt out of at any time by emailing us at blank with the clear subject line opt out. Now, they can't opt out of you having their address for fulfilling the order. That doesn't make sense. So it's only for any of those things that are not directly fulfilling the order. Has to be easy to find. I will point out that in California, some things are going to become an opt-in, meaning that you have to get the affirmative consent of your consumer. GDPR, there are also some things that are opt-in. So who's seen cookie notices on the bottom of the websites? That's often an opt-in in a lot of places right now. That means that they have to affirmatively agree, because that's a different kind of use of their data, such as their IP address and what they're looking for. So, but mostly we just have to give an opt-out right. Have to give the ability to unsubscribe. So let's say that they did sign up for your newsletter. Everybody's seen those constant contact emails there. You must always have an unsubscribe link at the bottom of the email that is easy to use, does not require them to give you a bunch of extra information, doesn't bribe them in any way to do it. So it's kind of an opt-out for that reason. But since they don't know a lot of the other things, an unsubscribe link is not equivalent to an opt-out, it's just an additional requirement. Access. Consumers have the right to access. That means that a consumer has the right to say, hey, Sam, are you using my birth date for anything? And I have to say, I have your birth date from this time that we did a case, and I was required to put in your birth date to get you damages, but I have not used it for anything else, and I have not sold it to anyone else. They could say, great, can you send me a copy of every place where you have my birth date? I have to say yes. I have to do it in a commercially reasonable time. I don't have to do it the next moment. I don't even have to do it the next day. And if that client has been closed for me, and so their personal information is in a vault in storage, then I have to have enough time to be able to go access that vault and pull it. But people have the right to know what a company is processing about them, and they have a right to access it in a data portable way, meaning that it can't be in some special legal software that we use here that nobody else can open on their computers without downloading the legal software. Additionally, we now have the right to correct inaccuracies in personal data. Now, this one gets a little hairy in certain industries. While people have the right to correct inaccuracies in their personal data, that doesn't create a right to change professional opinions. So if you're a doctor or a therapist or things like that, somebody can make sure that they change the date that they came into the office if you have that date wrong, but they can't say, oh, but therapist, your assessment that I'm doing okay, or that I need some medication here is wrong. You need to correct that. That's not their personal data. Personal data being spelling of names, birth dates, billing information, those kinds of things. So consumers have the right to correct that, and a company is required to correct it. That also sometimes is important for consumer fraud type things. If somebody else is using your information, you can say, whoa, hey, you've got my social security number tied to Joe over there. I'm not Joe, I'm Sam. You need to correct the fact that that's not Joe's social security number. So that's why this one is very important. It's less about the therapist appointment, just an important distinction to make. And also the right to have a company delete personal data. Consumers have the right to say, hey, company, I got my plant 3 weeks ago. I need you to delete my personal data. I need you to delete my address. You no longer have the right to have it. And a company has to comply within a reasonable period of time. Again, sometimes with certain industry regulations, the industry regulation will trump. Sometimes also if you have now aggregated that data, so you know that you had 70 clients in Fort Collins for the year and 12 in Westminster and 120 in Denver, but you can't tell who those are, you can keep that data if it's not personally identifiable anymore. So there are some limitations to the right to delete. And obviously, like we said before, you can't delete somebody if you still have to fulfill an order. At that point, you have to clarify that you can't do that at that point. If they still want the order, are they canceling, and what your refund policies and things like that are. And then we mentioned data portability. This goes back to the right to access. In the new privacy law, it's only going to be up to 2 times per calendar year. Arguably, the access right is unlimited. So it will be more that somebody can ask whether you have the information as many times as they want, but they can only ask you for a copy of it up to 2 times per calendar year. So that is actually a very helpful limitation for businesses on that front. And then timing, we talked about reasonableness. If you are covered by the CPA, so if you're covered by that Colorado Privacy Act, you're going to have 45 days to fulfill consumer requests. If you're not covered by the Consumer Privacy Act, it kind of raises questions. Some of these things you have to do anyway under data security. Some of them are good things to do as businesses. Generally speaking, I would say if you follow the timing of the CPA, you can't go wrong. Up to July 1st, 2023, the rule has been and will be reasonable for your business. So obviously that is a little vague. We're generally liking the fact that there's this timing requirement, but just it is technically only under the CPA. So if you get a request under another law or act, think of what's reasonable for your business and try and do it no later than 45 days. Those are consumer rights. Any questions on those ones before we jump into company obligations? And I promise you in the obligation sections, we're going to get to the driver's license question for restaurants and bars. But those are kind of the general things that consumers have the right to ask of businesses. So any questions on those?
Doesn't look like we have any questions right now, so feel free to type those in if you do, and we can get back to them at the end. I do just want to comment, I guess, on this section that perhaps the best practice is to only ask for information that you actually need and have a use for your business. I know setting up some of registration forms and things like that through different providers, there's so many options you can choose from, and sometimes it's easy to want to click them all because you get kind of curious about what type of consumer is interested in your product or service. But if you don't have a use for that information, you could just be, making yourself more vulnerable to some of these requirements than necessary.
Super smart, Hannah. Or another way for those of you who have the big marketing, it's almost like Hannah's been doing this for a while or something. For those of you who have the marketing bug, if you really are trying to figure out who your target consumers or clients are, if you have ways to do it in a survey where it's not attached to the person or the email address, that can be really helpful. Why? Because now it's not personally identifiable anymore. So if you are wanting to know where your consumers are located and you're just pulling that city name or the zip code and no other information there, we're not in personally identifiable land anymore. So it can be, if you really just can't give up that data bug, we all like big data. Big data is fun. Think about ways to pull. So best practices is collect only what is absolutely necessary for your business. Second best practices is collect it in a way that does not tie it to an individual person.
Yeah, great idea. There's another great question about, is there a difference between collecting information if you're business to business versus business to consumer?
That's a great question. So these consumer rights apply to businesses as consumers, but less strongly, because we worry a little bit less about the business's privacy. A business has more information that has to be out there, that has to be public. It just has fewer things that it can tie to this. But you want to think about it in a similar way. Could somebody defraud the business by getting this information? So if it's a business bank account and you're B2B, that's still going to have that protection, right? If it's a business's passwords, that's still going to have that protection. But things like address aren't going to be as strongly protected because that has to be public. Things like personal security questions are going to be much harder to obtain because that has to be, you're not going to have as easy of a time tying that in. So do businesses have all of the rights that we've said in here? I would argue yes, if the information collected would still allow you to defraud a business. So I would think about it that way. You're going to have less of a stringent time with it, but there are still those points that you need to be aware of.
Great, thank you. Those are the end of our questions for now. There is just another comment from Sierra about some third-party survey collection services where they'll send you the answers without access to the PII. So that could be a great way to protect yourself without having to get too far into some of that as well.
Absolutely. Great point, Sierra. And we really like those businesses for small companies because it really helps mitigate some of that risk. So, and in fact, we're going to talk now about the company obligations. You might think the consumer rights are also your obligations, but those are more of a things the consumer is entitled to do. And other than make sure that they have access to those things, you don't have a ton of active obligations. These are your active obligations. And we're going to talk a little bit about some of that third-party interaction here. So first obligation, internal privacy policy. And this is under the current law in Colorado. It's a good thing to have. Every company that takes in any PII whatsoever or uses it from a third party potentially is required to develop a written policy to ensure that that PII is properly disposed of when it's no longer needed, and to maintain reasonable security and practices to protect that PII when it comes in. Now, something Hannah said is absolutely applicable in here. If one of your written policies is we only take in the minimum amount of personally identifiable information that we need for each client contact to fulfill each order, that's a great thing to put into your internal privacy policy. This privacy policy is one of those things that a lot of businesses skip because it only comes up if you get in trouble. Nobody is going to ask you to file this with the Secretary of State. If you do get an insurance policy that protects you from cybersecurity or data privacy breaches, they will ask for this. So that's a good time to have it. But otherwise, people only need it once a breach has happened. And then the Attorney General says, okay, where's your internal privacy policy? And you go, I'm sorry, what? So what we want is you guys to not say, I'm sorry, what? And to say, here it is. Doesn't need to be long, doesn't need to be lengthy. And the nice thing is the statute actually has written into it that it needs to reflect the type, nature, size of business, as well as the type, nature, and size of the PII you collect. So if you are our plant seller and you're really only collecting addresses, email addresses, names for fulfilling an order, then you can have a much thinner internal privacy policy. If you're collecting the credit card information personally with that security code and the name associated with it, address associated with it, you should probably have some more stringent policies because that's stronger information that somebody could use to defraud your clients. So you're going to need special protections to protect that and know when do you get rid of those credit card numbers. You might get rid of the credit card numbers much faster than you get rid of those addresses, which you might get rid of much faster then you get rid of the email addresses, especially if they've signed up for your newsletter. If, however, you have a third-party credit card processor, so you never actually see the credit card number, you see the last 4 digits connected to this order, and that's it. You can write that in, that our privacy policy related to payments is that we never personally collect it. We always use a vetted third-party provider that has its own security measures and privacy policies, and that we do not store or keep any of that information. And we allow Square or QuickBooks or PayPal or whoever that is to keep it for us. And we have read to and agreed to their security and privacy policies. Well, all of a sudden, that's much easier for you. And that's a quick and easy sort of section to have in your internal privacy policy. Or as Sierra said, if your policy is to collect marketing information, but to do it through a third party, such that you only see the aggregated information and not any personal identifiable information, that's a great little sentence to put in there, that we may keep other information, but that we will never keep it in such a way that we could figure out who it is attached to. That goes into your internal privacy policy. Don't need a lawyer to draft it. Just whatever you are actually doing to properly dispose of things, how long you're keeping them, and what you do once you get rid of them. You do also need an external privacy policy. The key thing with this is it can't be inside terms and conditions, refund policies, things like that, if your client's only interaction with it is on your website. If there's a signed negotiated agreement between you and your clients, you can have it within that, because the idea is people are paying a little bit closer attention. And under California law, if you have a website that is targeted or accessible in any way by California residents, the privacy policy must be accessible from every page of your website with the word privacy in the link. So you can have a page that is terms and privacy, and then those two things need to be separate, but privacy must be in the link. If you just have terms and conditions, you're not compliant with California law if California residents can give information on your website. Needs to be reasonably accessible, easy to find, clear. This is one where legalese is a bad thing. And so you want people to understand what it means. You want it to actually say something meaningful. How are you using the information? Need to include categories of what personal data is collected or processed. Addresses, phone numbers, email address, all these things we're talking about here. What are the purposes? What of those do they get to opt out from? If they have other rights or appeals, like changing or deleting things, how do they contact you? Is it through your contact us form? Do you have a dedicated email address? How long will it take you to get back to them? Usually somewhere between 2 days and 14 days is reasonable to at least respond and say, we're on it, we're looking at this. What if they want to appeal how you're using it? What are you sharing with third parties, and who are those third parties? So if you are using a payment app, I highly recommend either identifying the payment app in there or linking to their privacy policies and saying, here's Square's payment app. If you have other third parties who you share personal data with, like a virtual admin or subcontractors, you need those categories in that privacy policy too. We will occasionally share these with subcontractors in order to provide you services. We will occasionally share these with marketing companies who will help us better target our products. And then if you are selling it to anyone, and that includes allowing people to mine your website for any reason, you need to disclose that. That one's absolutely affirmatively needs to be disclosed. So internal privacy policy, very informal, things that you do back end to protect people's stuff. External privacy, very clear but detailed of what you're doing with their data and why. And then you also have some additional duties that you can put in one or both of those. Need to be transparent. That's part of those privacy policies. Need to have a specification of purpose. Need to say why you're using this. Data minimization, that goes back to what Hannah said with best practices. She had an idea this was coming, I think, which is the only collect what you absolutely need or have a specific purpose for. Avoid secondary uses of personal data when you haven't disclosed them. So that's the sending the newsletter, sending out coupons. Duty of care just means be as careful with other people's data as you would want somebody to be with yours, or if you don't care about your personal data, as a reasonable person would. Try to avoid unlawful discrimination. You can, in fact, still unlawfully discriminate with data. If you are, let's see, for example, taking in potential clients or even employees. Let's say you sell cars and you decide you're only going to do credit checks on people who look like they might not be able to afford your cars. That's discriminatory. So if you are selective in what kind of data you collect from what people, and it is not specifically related to the difference between the services you are providing them in a non-discriminatory way, it's going to be a problem. And if you're going to be taking in sensitive data, it's always best to do that with consumer consent. Some laws will require that, some will not. Highly recommended for best practices anyway. And what do we mean by consent? Consent is a clear and affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement. Okay, here's the thing. We love that because it protects you as a business. As attorneys, I say we. It's not always practical. If I could, I would have each of you sit down with each of your clients and say, here is what we're using your data for. Do you consent? And have them say yes and then sign a thing. We can't get that most of the time. Negotiated contracts are best. If not, having to do a scroll through is next best before they sign on to something. Having the link at the point of sale is not my favorite, but is next best after that, and sometimes the only thing that's really practical. Having a reference at point of sale is usually not sufficient. So saying, go check out our privacy policy with no link is probably not sufficient. Not having to do the checkbox that they've actually read the privacy policy is probably not sufficient. Acceptance of terms of use without specifically calling out the privacy policy, not sufficient. So anything that requires a hover over or things like that, also not sufficient. Dark pattern agreements are basically, in 20 seconds or less, ones where you say, we're withholding your personal medical information until you sign this. It's basically taking a bad action in order to get somebody to agree to something. So that's never going to be okay. You can't hold people hostage. You can't hold their money hostage. You can't hold their needs hostage. You can say you can't buy this thing in the shopping cart until you agree to this. That's fine. But withholding required or necessary information and not telling them that you're going to do that until after you and kind of pulling in the privacy policy at the last minute, not going to be an acceptable consent. So we do have the duty to give good consent. And then we also do have a duty to audit ourselves. Now, a full official audit called a data protection assessment is only going to be applicable if you meet those requirements of the Colorado Privacy Act. So, you know, selling data of 25,000 consumers in a year, or working with 100,000. That doesn't happen with most of us. However, a good audit of our own systems is good from time to time. Typically, if you don't meet the requirement to do it, I recommend every 2 to 3 years. If you do meet the requirement to do it, you need to do it every year. I also recommend to do it if you ever have a breach. It's a good time to do it. And if you do ever have a breach and the Attorney General requests it, you are required to give it. So oftentimes you will need to do it if there's a breach and the Attorney General gets involved. If you are processing any data that presents a heightened risk of harm to a consumer, like biometrics or medical data, or if you are selling data, it's a good idea to do these at least once a year to make sure that you have the proper procedures. I also do recommend it if you're processing a lot of private information of children. It's just kind of an asking for heightened risk issues. Other risk factors would be if you have a potential for unlawful or for disparate impact, if you're dealing with financially or physically injured consumers, if you're dealing with data that might be offensive to a reasonable person, then you should also be doing these more regular audits. And then we also have a requirement to dispose of data. We don't actually have rules on when and how, unless you are in an industry that does. You just need some sort of policy. Typically, we recommend follow breach of contract statutes for how long, which in the state of Colorado is 3 years. If you have more sensitive data, delete it sooner. Have regular data deletion parties, data disposal parties, aggregation parties. We got to do it. It's a thing that we have to do. And if you're not following these duties, if you're not doing these things, it does go to the Attorney General of Colorado. It goes to the district attorney's office. It doesn't usually go to the consumers. Consumers don't usually have a cause of action for these kinds of breaches, but it can be considered a deceptive trade practice under the Colorado Consumer Protection Act if you are not fully disclosing what you're using data for, or if you're telling people they're opting out or they're getting access and they're not. And the Colorado Consumer Protection Act does have a private right of action. So usually if you're breaching one of these things, it's the Attorney General. If you have a security breach that raises these issues, the Attorney General investigates. There's a reporting function as far as that goes, but only if it's a deceptive trade practice can consumers do it. If you do have a breach, you have to provide notice to the affected residents within 30 days. You have to do a good faith investigation. You have to provide notice to the Attorney General office. There's an online form. They'll come in, they'll look at your processes. If you had good internal and external processes and this was not your fault, which does happen, they'll probably give a recommendation for how to improve it. You give your notification. If there is a big breach of financial information, you may be required to do some additional reporting to consumer agencies. You may get a fine. There are some fines in there. Sometimes they can require that you pay damages to the actual individuals to remedy their credit reports or credit history, as far as that goes. So those are some of your obligations. Driver's license. I am wrapping up because I do have to go right at 12. But driver's license, if you are at a restaurant and you want to require that people come in and you want to scan their driver's license when they come in. If you are looking at it once and then letting them go in and not retaining that information, you're fine. There's no issue there. If you're using a machine that stores it, say, for 10 to 14 days, so that if you get investigated or audited, that you can show that everybody who came in here in the last 10 to 14 days absolutely was compliant with this one, and then it gets appropriately deleted afterwards, you should be fine. If you're keeping it for longer than that, I would say there better be a really good reason. So let's say you're a liquor store and that you're wanting to keep member licenses on file. I would think heavily about whether there's a better way to do that. So if you have a membership agreement and people agree to provide their driver's license number, which can be checked into the system, you know, is there a better way to do that? Is there a way to check it in once and show that they've been verified and have them re-verify once a year? Is there a way to keep the driver's license number but only have the last 4 digits accessible? So, you know, we're going into those best practices as far as that, only collecting what you absolutely need. If you do absolutely need it, or if it makes your business model better, keep it for as little time as absolutely necessary, and apply those good maintenance and disposal policies. Really check with your people that you're hiring to make sure that that's good. Know who gets that. And then give clients the ability to opt out. Can they come in and just not be allowed to drink? Does that harm your business model in some way? If it does, then they can choose not to use your services. But you absolutely have to disclose to them how long you're keeping it for, you know, what you're using it for, if you're using it for any other purposes, and what laws could and could not apply. And then once you actually have those policies, follow them. So any other questions? That was a lot. We scrambled through that. We've got 5 minutes for more questions. And then of course, you can always reach out to us. That's my paralegal's email on the screen, because she can be a little faster sometimes at getting you onto my calendar during busy times. Hannah, what other questions do I have?
Yes. Yeah. Great content. It was pretty thorough. So there's not a ton of questions, but there are a few. There's one that Kevin has about federal government contracting data requirements. And I'm not actually familiar with these acronyms. Looks like FAR and DFAR regulations. Do you have any comments on that?
Yeah. So typically, if you are going to have government contracts, you are going to need to be compliant with the FAR regulations for the type of information that you collect. I said a lot of people don't ask for your internal privacy policies. If you have a government contract, you have to show that you have appropriate security measures for any of that PII that you collect, that you're not using more PII on a government job than you have to. Oftentimes, you may even have to sign something that says you understand the government requirements for PII, and that everybody who works with you has to sign a confidentiality agreement that says that they understand the same. Typically, I do recommend that if you are going to do government contracting, you do a bit of an internal audit with your policies and with what you're actually collecting specifically, to make sure that you are fully compliant on that one. So that's the best I can give you right now without going into all the details of what your company does. But I would take this very seriously if you're doing government contracting.
Yeah, no, that makes sense.
Yeah.
Yeah, it's the FAR is the Federal Acquisition Regulations, I think, and then D is Defense Federal Acquisition.
Yeah, and the DAR are very in-depth, and you have to make sure that you have the appropriate provisions in your privacy policies that match with the appropriate DAR regulations for the particular types of information you're collecting. So it's really one of those things that's best to get an attorney for and do just like a line by line with the statute that meets the types of services that you're meeting. Sorry.
No,
that's a lot of work.
I know. I spent a lot of time reading FAR regulations, and it's hours of just a lot of words.
It's a lot of words. It's a lot of words. So that is definitely one where if you wanted to set up a consult with me, you can reach out to Hannah in the SBDC office, and we can sit down and talk about that.
Great, appreciate it.
Yeah.
Great, thanks, Sam. And just one more quick question, and I think this one kind of goes back to maybe some of the industry specific regulations on how long you can keep data. But this question is about for vacation rental owners keeping data from past guests that they've had at their property. Looks like their spreadsheet might go back several years. Is that a breach, or how do you know when you really need to dispose of that data?
Well, so here's the risk. If you are at the moment, there's no law saying at date you have to get rid of it. However, if you got hacked, then you have to go back and notify every single person on that list. And if it was personally identifiable information, you may have fines for every single person on that list. So at some point, it's a question of what is the risk assessment on that one? Typically, I recommend 3 years. If the last time they stayed with you was longer than 3 years ago, it's probably time to purge them. That's my general best practices regulation that keeps it manageable. If you have really good reason for wanting to keep them on, I might look at minimization after that 3-year period. What is the minimum amount that you need to keep?
Yeah, it makes sense. Any thoughts about keeping data on a laptop versus keeping data on a cloud service?
This applies to laptops, cloud services, in-person files, anything like that. So we're kind of agnostic as to where you keep it. The benefit to keeping it on a cloud service is if you can pay for an encryption service, that makes it harder to hack. That's a reasonable security measure. If you're keeping it on a laptop, the laptop's encrypted, that might be a reasonable security measure. So, I think there are pros and cons to each. I think as long as you're taking reasonable security measures for what you're doing, there are plenty of cloud services that allow that, and there are plenty of ones you can do on an individual laptop.
Great. Thank you so much, Samantha. I know we are coming up on the hour. There are some more questions. So if you have other questions, we really encourage you to connect with Samantha. I'll include some links in our follow-up email. You can dive a little bit deeper into what your specific situation might be. So again, all of this content will be coming to you this afternoon, so you can refer back to it. And thank you all so much for joining us. And thank you, Samantha, for all of this great information. It's been so helpful.
Absolutely. And like Hannah said, if anybody has questions, feel free to reach out for a consult. Happy to chat offline.
Great. Thanks, Samantha. Thank you all. Hope you have a great rest of your afternoon.
Bye, guys.